Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law Number 2. This morning, you have been asked to come to court for what we call an arraignment. And what the arraignment is, it's an opportunity for the court to tell you what you've been charged with, what your rights are, and what your options are concerning your case. Now, the case that you have in this court is a criminal case. It is a misdemeanor criminal case. Criminal cases are divided into felonies or misdemeanors. The felony cases are normally referred to as your most serious type offenses, whereas your misdemeanor cases are referred to as petty offenses. It does not mean that they're not serious. It just means that they're not as serious as a felony offense. And when I use the term serious, what I'm talking about the facts of the case and the possible punishment that a person can receive if they are convicted of the offense. Now, as a defendant, when we talk about the felonies and the misdemeanors, and we're talking about punishment, your felonies are divided into 5 categories. And we'll start at the top and work our way on down to the bottom. You have the capital murder, first-degree felony, second-degree felony, third-degree felony, and a state jail felony. Now, if a person is convicted of a state jail felony, the range of punishment is minimum 6 months to a maximum of 2 years in the state jail and a fine that does not exceed $10,000. If a person is convicted of a third-degree felony, the range of punishment is minimum 2 years to maximum 10 years in the state penitentiary and a fine that does not exceed $10,000. If a person is convicted of a second-degree felony, the range of punishment is minimum 2 years to a maximum of 20 years and a fine that does not exceed $10,000. If a person is convicted of a first-degree felony, the range of punishment is minimum 5 years to a maximum of 99 years to life in the state penitentiary and a fine that does not exceed $10,000. Now, if a person is convicted of the highest felony, which is a capital murder, the range of punishment is minimum life in the state penitentiary without the possibility of parole or death by lethal injection. Now, as I mentioned to you earlier, your case is a felony case, so you don't have to worry about those type of punishments. Misdemeanor cases, which your case is, are divided into 3 categories. We'll start at the top, work our way on down to the bottom. You have the Class A misdemeanor, the Class B misdemeanor, and the Class C misdemeanor. Now, your Class C misdemeanors are cases that start in the JP court or the city court, and they come to this court when a person appealed the case. They are convicted in the JP court or the city court, they appeal the case comes to this court. Now, the range of punishment for a Class C misdemeanor is fine only. The fine cannot exceed $500. So you cannot be given jail time. It's fine only. Anywhere from $1 to $500. Okay. Now, if a person, however, fails to pay the fine, or if the fine was converted to community service and they failed to perform the community service, then the court can issue what is called a capias pro fine. That means that the court can issue a warrant for their arrest for them to either pay the fine or to sit the fine out in jail at $100 credit per day. All right. Now, an example of a Class C misdemeanor would be like not having your seatbelt on, or like speeding, those type traffic offenses. Now, the next highest misdemeanor is a Class B misdemeanor. With the Class B misdemeanor, the range of punishment is minimum 0 days to a maximum of 180 days in the county jail, or a fine that does not exceed $2,000, or you could be given both jail time and a fine. The highest misdemeanor is a class A misdemeanor. With the class A misdemeanor, range of punishment is minimum 0 days to a maximum of 365 days, which is 1 year in the county jail, or a fine that does not exceed $4,000, or you could be given both such jail time and a fine. Now, you may be eligible for probation. There are 2 types of probation. One type of is called unadjudicated probation, and the other type is called adjudicated probation. Now, with the unadjudicated probation, it does not result in a conviction on your record. And if you successfully complete the probation, case will be dismissed. You not have a conviction on your record, and you may qualify for what we call a non-disclosure. A non-disclosure basically means your record is sealed to the general public. Now, you notice I said general public because the general public cannot have access to it. However, the government, there are certain government agencies that are listed in the Code of Criminal Procedure that can have access. But most of the public is the general public. So most of the public, which is the general public, cannot have access to it because your record is sealed. All right. Now, the other type of probation is called adjudicated probation. You got unadjudicated probation and adjudicated probation. Now, with the adjudicated probation, it does result in a conviction on your record. We usually call it regular probation. Now, there's something that is called judicial clemency, where the court or the judge can set the conviction aside and you would no longer have a conviction. In order to qualify for judicial clemency, 3 things has to happen. You have to successfully complete the probation. There cannot be any more time left on the probation. And you have to be discharged from the probation by the probation department. If those 3 things happen, then the court has the discretion to set your conviction aside and you will no longer have a conviction on your record. However, if you get a subsequent conviction, in essence, you get another conviction later on, then the conviction that you receive judicial clemency on can be resurrected, revived, brought back up, and it can be used against you. And if you try to get a license with CPS, Child Protective Services, they could either deny giving you a license, or if you have a license, they can suspend or revoke that license. Okay. Now, as a defendant in a criminal case, you have rights. One of the rights, or the first right we're going to talk about, and it's on the clipboard, is your right to have an attorney. Everyone who's here for court should have a clipboard. On that clipboard, the first document should be judge's explanation of rights to defendants without an attorney. The document should look like this. On this document, it states that as a defendant in a criminal case, you have 3 options regarding the right to have an attorney. Number 1, you may hire an attorney. You have that document? Do you have this document?
Yes.
Okay, this is the document we're going to be looking at. Number 1, you may hire an attorney. Number 2, if you like to have an attorney to represent you, but you do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you. And number 3, you may represent yourself. Now, the first paragraph states that if you'd like to have an attorney to represent you and you have enough money to hire an attorney, your case will be reset. Reset means you'll be given another court date to give you time to hire your attorney. Second paragraph states that if you'd like to have an attorney, but you do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you, but you must first fill out the financial questionnaire. Okay, so that the proper person can determine whether or not you qualify for an attorney. Now, questionnaire is another document on the clipboard that is titled Johnson County Affidavit of Injury. The document looks like this. It is a 3-page document. You would have to fill out the first page. And then if you turn to the second page, you will fill out the top portion that says defendant's oath. And then you go to the, almost to the bottom where it says unsworn declaration of defendant. You'll fill that out and then you'll stop. And that's all you would have to do. Now, The next paragraph, going back to our judge's explanation, the next paragraph states that you may not talk to a prosecutor unless you first sign a written waiver of your right to be represented by an attorney. Now, the written waiver, now this is for individuals who will be waiving their right to an attorney. And that's you have a right to represent yourself if you desire to do so, but you have to waive or give up your right to have an attorney. And if you do that, then you will be representing yourself, you'll be acting as your own attorney. Now, the document that you have to sign, the waiver is titled, there's another document on the clipboard that is titled Waiver of Counsel for Purposes of Entering Guilty Plea or Proceeding to Trial. You have to read this document, sign, and date. Now, if we go back to the main document, which is the judge's explanation of rights to defendants without an attorney, the second to the last paragraph states, and it's for individuals who like to waive their right to attorney, said, be aware that the dangers and disadvantages of self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant rights and opportunities related to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. Now, the last paragraph states that if you choose to represent yourself, you may change your mind at any time and request that an attorney be appointed to represent you. Now, at the bottom of this document, in bold letters, it states defendant's choice. Marking issues next to only one choice. If your choice is to hire your own attorney, then you'll place your initials on the first line to the left. If you have already hired an attorney to represent you, then you'll place your initials on the second line to the left and the name of the attorney on the line to the right. If you would like to apply for a court-appointed attorney, then you will place your initials on the third line to the left. If you've already been appointed a court-appointed attorney to represent you, then you will place your initials on the fourth line to the left and the name of the attorney on the line to the right. Do you have this document? Okay. And if you would like to waive or give up the right to have an attorney, then you'll place your initials on the fifth line to the left. And then once you finish initialing one of the lines, one of the 5 lines, then you will sign your name on a line that is titled defendant, and you will date it today's date, April 1st, 2025. Okay. Now, just as a brief recap, first of all, everyone is going to sign this document. If you want to hire an attorney, you're going to place your initials on the first line. If you want a court-appointed attorney, you place your initials on the third line. If you would like to represent yourself, you'll place your initials on the fifth line. Once you place your initials on one of these lines, then you'll sign and date. Okay? And those individuals who are applying for, now, if you just hire an attorney, this is the only document you're going to sign. You don't have to sign nothing else. Okay, if you hire an attorney, this is it. If you are applying for a court-appointed attorney, you'll initial this document on the third line, and you would have to fill out the affidavit in English, fill out the first page, and then we go to the second page where it says defendant's oath at the top. You fill that out, and through what says unsworn declaration by defendant, you fill that out, and then you'll stop. Now, if you are applying, well, if you are desiring to represent yourself, then once you place your initials on the fifth line, indicating that you would like to waive your right to attorney and represent yourself, then you would have to read and sign a document that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. Okay, anyone have any questions? Okay. Anybody have any questions? Yes.
If I already had an appointed lawyer, I can still keep that lawyer.
If you had an appointed lawyer from here, this court, you would keep that lawyer. If the lawyer is appointed on some other case, like in another, like in felony court, or they're not on this list, then you have to apply for a lawyer here. So,
Mr. Reverend,
uh, let's see, hold on a minute. Okay, what's your name?
Leslie Hill,
Leslie Hill.
Mr. Holmes was, I guess, reported for them.
What page?
Case.
Oh,
I mean, it's not showing that she has one yet.
it's not,
No,
what page she on?
On page 6.
He was in the drug court case.
Probably for a previous case.
Yes.
Oh, it's on a different case. This is, yeah, that was on,
okay, I was saying, can I use him here?
we go down the list.
Oh, okay.
It's, we have what is called a wheel. And so whoever comes up, so you can't, whoever comes up. Okay. All right. Okay, anybody else have any other questions? Okay, now, the next thing we're going to do, I need to, I'm gonna tell you about your right to your other rights, some of the other rights that you have. One other right that you have is, you have a right to have a jury trial. If you decide that you like to plead not guilty, you want to try, you have a right to have a jury trial. Where a young lady is sitting, we call that the jury box. 6 citizens from Jefferson County will be selected as jurors. On your case, they will listen to all of the evidence, listen to the arguments of the attorneys. They will deliberate and they will decide whether to find you not guilty or guilty of your charge. You also have a right to waive or give up your right to have a jury trial. If you waive or give up your right to have a jury trial, then your case will come before the court or the judge in one of 3 ways. One way you can come before the court is by way of a trial. Now, somebody might say, well, how can it come by way of a trial if I'm waiving my right to jury trial? Well, you might waive your right to a jury trial. However, there's something that is called a bench trial, a trial by judge only. The judge will be the judge and the jury if you desire to have a trial without a jury. We call it a bench trial. Now, the judge will listen to all of the evidence, listen to the arguments of the attorneys. The judge will apply the facts of the law and then decide whether to find you either not guilty or guilty of your charge. Now, you also have another way that your case can come before the court is by way of a plea bargain. What a plea bargain is, it's an agreement that you're able to work out with the state to settle your case. They call that a plea bargain. So, if you're able to work out an agreement with the state, we call that an agreed plea bargain. In essence, you worked out an agreement, you agreed to, like, for example, let's say y'all worked out an agreement where you get probation. Or some other type of punishment. If you agree to it, we call it an agreed plea bargain. Then it comes before the judge or the court. And the judge can do one of 2 things. The judge can accept the agreement or reject the agreement. Now, if the judge rejects the agreement, then you have a right to withdraw or take back your plea. You would say, well, judge, since you're not following the plea bargain agreement that I made with the state, I will withdraw or I will take back my plea. And that's it. I'm not pleading guilty and I'm not pleading no contest anymore. All right. Now, since I'm there, no guilty basically means when you say you're guilty, you're telling the court that you committed the offense that you've been charged with. If you enter a plea of no contest, you're telling the court that you will not be fighting or you will not be fighting or contesting the charges that have been brought against you. If you enter a plea of not guilty, you're telling the court that you did not commit the offense that you've been charged with. So in order to enter a plea, it'll be guilty. If you get entered into a plea bargain, it'll be either guilty or no contest. All right. Now, the other thing is, if the judge follows a plea bargain agreement And if you decide that you would like to appeal your case, in essence, you think that you might have been wrongfully convicted or this court committed an error by convicting you, and you would like to have a higher court to look at your case, to see whether or not you've been wrongfully convicted, or whether or not this court committed an error, we call that an appeal. Now, the appeal, if you file an appeal, you have to get permission from the judge that followed the plea bargain agreement to appeal the case. If the judge gives you permission, the case is gonna leave this court, and it's gonna go to the Ninth Court of Appeals, which is right upstairs on the third floor. 4 judges up there who will review your case. They can do one or two things. They can accept or reject, or meaning they can grant or deny your appeal. If they grant your appeal, they can just simply find you not guilty, case over. Or they can send the case back down to this court and order this court to give you a whole new trial. Now, if they deny your appeal, then at that point, you can appeal your case to a higher court than the Ninth Court of Appeals. You can appeal it to the highest criminal court in the state of Texas, which is located in Austin, Texas, and it is called the Texas Court of Criminal Appeals. You would have to file what we call a pro se petition for discretionary review. What that means is you'll be representing yourself. That's what pro se means. And you'll be petitioning the court or asking the court to review your case to see whether or not your appeal should have been granted, or whether or not this court wrongfully convicted you or committed an error by convicting you. They can do one or two things. They can grant or deny your pro se petition. If they grant your pro se petition, they can simply find you not guilty. Case over. Or they can send the case back to the Ninth Court of Appeals with orders, or they can send it back down to this court with orders. Now, if they deny your pro se petition, then at that point, your conviction will stand. Okay. Now, the other type of plea bargain is if you're trying to work out an agreement with the state, but you cannot come to an agreement, but you still want your case settled because you don't want to go to trial. So there's something that's called an unagreed plea bargain, where the judge will set the punishment. In essence, the judge would set the punishment anywhere within the punishment range of your offense. Judge can give you anywhere from, like we say, jail time, fine, both jail time and fine, or probation, either deferred or straight. Unadjudicated probation or adjudicated probation. So the full range. So the judge will be the one who's setting the punishment if you're unable to work out an agreement with the state. Okay. Now, the other right that you have is you have a right to have witnesses to come to testify in your case. Witnesses sit in their chair with a microphone, as we call that the witness stand. And what witnesses do, they can testify for you or against you. If you represent yourself, you can ask them questions. You have a lawyer, your lawyer can ask them questions. We call that either direct examination or cross-examination. Now, you also have a right to waive or give up the right to have witnesses to come to court. If you waive or give up the right to have witnesses to come to court, that simply means that you will not be calling witnesses. Does not mean that the state will not be calling witnesses, because they will be calling witnesses in the case. You also have what is called a Fifth Amendment right against self-incrimination. That means that you have a right not to testify against yourself in your case. I know a lot of times we watch television shows like Law and Order, and we might see someone in court on the witness stand and they say, I take the fifth. What they mean is that I'm exercising or I'm invoking my Fifth Amendment right against self-incrimination. The Fifth Amendment is from the United States Constitution, where you have a right to remain silent. You don't have to testify against yourself. The state, the government, the DA's office cannot force you to take the witness stand if you exercise your right to remain silent. Now, you can waive or give up your right to remain silent. And if you do so, then that means that you will be testifying in your case. The other right that you have is a right to have what is called discovery. What discovery means is you have a right to see the evidence that the state has in their file, what the evidence that the state will be using against you. You have a right to have access to it. You have a right to have and see witness statements, your statements, police reports, lab reports. You have a right to see photos, video recordings. listen to audio recordings, have a right to see documents or any type of instrument, whatever the state has, you have a right to have access to it. That's called discovery. Now, you also have a right to waive and give up your right to have discovery as well, which means that if you waive and give up your right to have discovery, you will not have access to that evidence. Now, everyone that's here for arraignment, you have been charged with an offense, you've been arrested, placed in jail, you bonded out of jail, you're either out of jail on a cash bond, which means you paid the full amount of the bond to get out of jail, you're out of jail on a surety bond, which means you pay a bondsman a percentage of the bond to get out of jail, or you're out of jail on what is called a PR bond or personal recognizance bond, which means that you did not have to pay any money to get out of jail, you was only released under your own personal recognizance with a promise to appear here in court. I've said that to say this. Every day that you spent in jail, it can be used as credit towards your punishment. Now, the applicant word that I've used is every day that you spent in jail. And the reason why I say that is because, let's say you were arrested at 11:59 p.m. last night. And then you got out of jail 2 minutes later at 12:01 a.m. this morning, 2 minutes later. You get credit for 2 days. Why? Because it's 2 different days. It's only 2 minutes, but it's 2 different days. Okay? And so every day that you spent in jail, you get credit for that time. So for example, let's say you spent 5 days in jail. You talk to the state is offering that you serve 5 days in jail. That means you won't have to serve any more time in jail because you've already served 5 days in jail. Therefore, you'll be given credit for the time that you've already served. Now, if you serve 5 days in jail and they offer 7, that only means you have to serve 2. Because we don't subtract 5 from the 7, that leaves 2. Now, every day that you spent in jail, let's say you're in the state is offering you a fine in court costs. Now, every day that you spent in jail, you're credited at $100 per day that can go towards your fine in court costs. So if you spend 5 days in jail, that's $500. That will go towards your fine and court costs. If the state is offering you fine and court costs of $500, you won't have to pay anything. Why? Because the 5 days you spend in jail is already paid off. Therefore, the fine and court costs will be taxed and retired. Now, if they offer $700 fine and court costs and you spend 5 days in jail, that means you don't have to pay $200 because we will subtract 500 from the 700, that leaves you 200. And you'll be required to pay the 200 on the day that you dispose of the case. Now, if you cannot pay the $200 on the day that you dispose of the case, no problem, because the law allows the court to put you on what is called a payment plan. You can pay off in small monthly installments until it's paid off. Now, if because of this financial situation, you might not be able to pay it off, no problem. We can do what is called, we can convert your fine and court costs to community service. And with the community service, it's $12 and you get $12.50 that is credited toward your fine and court cost for every 1 hour that you perform in a nonprofit organization. So in our scenario, if you work 8-hour days in a nonprofit, 8-hour day, 8 hours in 1 day in a nonprofit organization, that's $100. Okay? So in our scenario, if you work 2 8-hour days, that's $200, fine and court costs is paid off. All right. Now, Jefferson County has a program that is called pretrial diversion. If you haven't been in trouble before, it's for first time offenders. And when I say Jefferson County, I'm talking about the district attorney's office. With that program, they will dismiss your case. And once you complete the program, you can get the case wiped off your record. We call it expunged. You can get it wiped off, deleted, or erased, expunged from the record. In order to qualify for the program, 1, it has to be the first time getting in trouble. 2, it cannot be an offense involving unlawfully carrying a weapon or resisting arrest. And 3, you have to have an attorney to assist you with the application process. Okay? And that's all it takes to basically get into the program. Now, if you're a veteran of any one of the branches of the United States military, the VA's office also has a program that is called Veterans Court. And with the Veterans Court, it's for veteran only. Only thing you have to do to get in the program is be a veteran at any one of the branches of the United States military. With the veterans program, you get into the program, and once you complete the program, they dismiss the case, and you can get what is called a non-disclosure, where your record is sealed to the general public. All right. Now, this court, County Court at Law number 2, Jefferson County, Texas, has a program that is called the CSI program. CSI stands for Community Safety Initiative. It is a program that God led me to start in March of 2017, within the first 100 days of me taking office. And with this program is designed to address the issue of what we call recidivism. And when I talk about recidivism, is where people commit crimes over and over. And so with this program, we have partnerships with agencies in our community. And one of the agencies that we have a partnership with is Spindletop. And Spindletop, we have some folks here from Spindletop. They're gonna come and see you in a few minutes and tell you a little bit more about the program. But with Spindletop is our local mental health authority. And Spindletop has expertise to address mental health issues that individuals may have. And with the Spindletop program, basically what they'll do, they'll conduct what is called a private interview, either in our jury room at their facility, by telephone, or whichever is convenient for you. Also, they have the ability to do what is called an assessment to determine what your mental health issue may be, and then they can develop a treatment plan, either outpatient or inpatient treatment. Spindletop also has a program that is called ATAR. ATAR is an acronym, ATAR, and it stands for Addiction Treatment and Recovery. And we have a partnership with our local Drug and Alcohol Council that has a program that is called OSAR, OSAR, which stands for Outreach, Screening, Assessment, and Referral. Both of those programs are drug and alcohol recovery programs. And what they will do, they will do a screening and an assessment and develop a treatment plan for either outpatient or inpatient treatment. If you're unemployed or if you're looking for a better job, then we have a partnership with the Golden Friday Empowerment Center, who has a partnership with Lamar University. And Lamar University has a program that is called CICE, and that stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training program and a job placement program in the hotel industry, the shipping industry, and the chemical industry. Once you are trained in any one of the areas that you select, they will help you to get a job in the field that you are trained in. And I usually tell people this: a lot of times individuals go and apply to jobs, they have training and go to apply to jobs on their own. And sometimes, a lot of times, they don't get the job. But when you go through this program, CICE go and apply for the job on your behalf to get the program, because the folks know about the success rate of CICE. If you have not graduated from high school, or if you do not have a GED, graduate equivalency diploma, then CIC also has a GED program where you can get your graduate equivalency diploma. Now, all these programs that I just mentioned to you are free. Does not cost you anything but time. And I like to say in this court, we do not just give time, we take our time. And that means that we do not just arrest the problem, we address the problem. And if we believe that if we address the problem, we can produce productive people. And if we produce productive people will not commit crime because they have too much to lose. And so I like to say that when you come to county court at Law number 2 of Jefferson County, Texas, we do not just have court as usual. We have unusual court. And it's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that come before this court. And if we make a difference in their life, we'll make a difference in their home. And if we make a difference in their home, we'll make a difference in the community, because what comes out of the home goes into the community. So if you're interested in any one of these programs, just let us know. And we have brochures that we can give to you so that you can get started in any one of the programs that I just mentioned. Now, at this time, we have Deputy Barry and Caitlin from Spindletop. They're going to come to you and tell you a little bit more about the program that Spindletop has to offer. You're welcome.
Hi, good morning, ladies and gentlemen. My name is Patricia Berry. I am a deputy in Jefferson County Sheriff's Office. I'm also a liaison with Spindletop Center. My partner Caitlin here is a qualified mental health professional. We partner in the ASAP program, which means assist, stabilize, and prevent. Now, the reason that we're here today, the judge has graciously allowed us into his courtroom. He cares about each and every one of you, okay? And we're here to provide resources today. Statistics have proven that people who enter the criminal justice system oftentimes have mental health needs that are not being addressed, or substance abuse issues, or just simply a lack of resources. And that's what we're here to provide you today, the opportunity to work with those resources. Now, the paperwork that we gave you upon entering the courtroom is strictly voluntary. You're not required to fill this out, but if you do and you'd like to give it back to us, you'd like to for us to contact you or reach out, Ms. Caitlin here is gonna tell you how to fill it out quickly and how you can contact us.
At the top of the paper is basic information. It's name, birthday, phone number, and email. We need these things to contact you and to put you in our system. Under that is how you like to be contacted, and that's call, text, or email. Whatever you check on the paper is how I will contact you. I will not contact you unless it's checked on this paper. Under that is what you need help with, and most of the resources would be either email you links or forms for you to email you links or forms for you to fill out yourself. You'd have to go through the whole process yourself, but you were to check mental health, which can be depression, anxiety, or PTSD, or substance use, which can be any type of drug or alcohol. Then you can work with Spindletop that we can get you the support and resources that you need. Everything else is pretty much self-explanatory. If you want to talk to me today, write anywhere on your paper, please talk to me today in person. And after the judge calls you up, I'll come back and I'll pull you to your room. And we can talk privately. You can either talk to me or you can talk to Officer Barry. Or if you want me to call you anytime today, you can put that on the paper. If it doesn't matter when I call you, you can check the call box and I'll get to you sometime this week. Judge is gonna go into recess shortly and you'll be able to fill out all of your forms. If you have any questions or if you need anything, you can call me or you can call Officer Barry and we'll come and try to help you. Like you said earlier, this is voluntary. You do not have to fill this out. If you don't want to fill it out, you can pass the papers to us and they can be blank. That's fine too. Okay, and that's it. Thank you.
Okay, thank you, Katie. Okay, ladies and gentlemen, we get ready to go into recess in a few minutes. I need to give you, I guess, some additional instructions. Before we go into recess, we want to make sure that you conduct yourself accordingly, because once we go into recess, we will still in court. Now, it's going to take you some time to fill out that paperwork. Once the paperwork is completely filled out, we're going to pick up the paperwork from you. We're going to call you up one at a time before the bench. And we're going to put you in one of the three categories, whether you want to hire an attorney, whether you want to put upon an attorney, or whether or not you want to represent yourself. Now, if you need any help filling out the paperwork, we have our core personnel who's here, who is available and willing to help you fill out the paperwork. If you need to use the restroom, there are two restrooms right outside the door in the hall. The men's restroom is in front of County Court Law number 3. The women's restroom is on the opposite side of the hall in front of the 172nd District Court. Now, you're allowed to go out into the hallway, use the restroom. Now, please do not leave the courthouse. Leave the courthouse, and if your name is called, and you're not here when your name is called, then your bond can be forfeited, and a warrant can be issued for your arrest. You'll be arrested, placed in jail, and then we have to go through this process all over again. All right? And so, again, just conduct yourself accordingly. If you need help with the paperwork, is simply simply raise your hand. Either, someone else in the court, with our court personnel or myself, we'll actually come up and we'll help you with the paperwork. So at this time, we do not have any questions. The court will be in recess.
Okay, please complete the clipboard before you go out. If not, you're gonna prolong yourself.
Court is back in session with the arraignment docket on today's date of April 1st, 2025. First case is Norris Gallo. Mr. Gallo, would you please come forward? You have two cases, cause number 25 CCCR 0262 and cause number 25 CCCR 026. You're gonna stand right here in the front. Okay, Mr. Gallo, your full name is Norris Gallo?
Yes, sir.
Okay, Mr. Gallo, would you please raise your right hand? Mr. Gallo, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Gallo, you may put your hand down. How are you doing, Mr. Gallo?
That's
I'm blessed as well. Now, Mr. Gallo, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
yes, sir.
Is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line that state you would like to have your case reset to hire your own attorney?
Yes, sir.
Mr. Gallo, before you sign and initial this document, did you read the document?
Yes, sir.
Did you understand what you read?
Yes, sir.
Is everything in this document true and correct to the best of your knowledge?
Yes, sir.
Okay, Mr. Gallo, your case is going to be reset. To give you time to hire your attorney, our court coordinator is going to reset your case. Once she resets your case, you'll be free to go. And you have a blessed day. Please have a seat in that first chair on the wall. I need some bond conditions. Darren Devon Gloud. Mr. Gloud, your full name is Redarian Devon Gloud.
Yes, sir.
Mr. Gloud, would you please raise your right hand? Mr. Gloud, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Gloud, you may put your hand down. How are you doing, Mr. Gloud?
Good.
That's good. Mr. Gloud, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line that state you like to apply for a court-appointed attorney?
Yes, sir.
I think he put his initials on the wrong line. He
Did.
he put it on the one saying he already had one.
Oh.
No, no. Now, Mr. Gloud, these are your initials on the line that state you like to apply for court-appointed attorney.
Yes, sir.
I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes, sir.
And is this your signature on the line that is titled Defendant Signature?
Yes, sir.
Mr. Gloud, before you signed and initialed these documents, did you read the documents?
Yes, sir.
You understand what you read?
Yes, sir.
Is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Gloud, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney, and the attorney that will be appointed to represent you is Attorney Jennifer DeLodge. Ms. DeLodge will be given information to contact you, and you will also be given information to contact her. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go and you have a blessed day. Please have a seat in that first chair on the wall.
Yes, sir.
Leslie Hill. Miss Hill, your full name is Leslie R. Hill?
Yes.
Okay, Ms. Hill, would you please raise your right hand? Ms. Hill, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Ms. Hill, you may put your hand down. How are you doing, Ms. Hill? You doing all right? That's good. Now, Ms. Hill, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? And is this your signature on the line that's titled Defendant?
Yes.
Or are these your initials on the line that states you'd like to apply for court-appointed attorney?
Yes.
Have another document that is titled, excuse me, Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes.
On page 2 of this same document, there's a signature above the line that's titled Defendant Signature. Is this your signature? Now, Ms. Hill, before you signed and initialed these documents, did you read the documents?
Yes.
Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge?
Yes.
Ms. Hill, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. The attorney that will be appointed to represent you in this case is Attorney Ryan Matuska. Attorney Matuska will be given permission to contact you, and you will be given permission to contact him. Our court coordinator is going to give you that information. Once she gives you that information, you'll be free to go, and you have a blessed day. Please have a seat in the second chair on the wall. Holly Perky. Let's do that in a second. Miss Perky, your full name is Holly D. Perky? Miss Perky, would you please raise your right hand? Miss Perky, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Miss Perky, you may put your hand down. How are you doing, Miss Perky?
Good.
I'm doing fine, thanks for asking. Miss Perky, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes.
Is this your signature on the line that's titled Defendant?
Yes.
And are these your initials on the line that state you'd like to apply for a court-appointed attorney?
Yes.
I also have another document that is titled Jefferson County Affidavit of Indigence. You recognize this document? On page 2 of this same document, there's a signature above the line that is titled Defendant Signature. Is this your signature? Ms. Perky, before you signed and initialed these documents, did you read the documents? Did you understand what you read?
Yes.
And is everything in these documents true and correct to the best of your knowledge? Ms. Perky, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you is Attorney Jack Lawrence. Attorney Lawrence is in court. Mr. Lawrence is going to give you information to contact you will also be given information to contact him. Our court coordinator is going to give you that information. Now, before she gives you that information, I need to give you some bond conditions in this case. And you'll be able to get a copy of these bond conditions along with your reset. Okay, Ms. Perkins. The document I have is titled Standard Bond Conditions in County Court at Law Number 2 of Jefferson County, Texas, and it states as follows. Following the return of a criminal information in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or of the United States. You understand that condition?
Yes.
Condition number 2, defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and arrest any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs or alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
Condition number 3 does not apply. However, condition number 4 does apply because your offense is a DWI second, which is listed as a subsequent offense listed under section 49.04 through 4906 of the Texas Penal Code. And condition number 4 states the defendant whose information charges any subsequent offense listed under section 4904 through 4906 of the Texas Penal Code shall not operate any motor vehicle unless the vehicle is equipped with an interlock device mechanism that makes impractical the operation of the vehicle if ethyl alcohol is detected in the breath of the operator. And said device shall be installed at the defendant's expense with written verification of such installation being submitted to the court on or before 3 days after the day. Do you understand that? Condition number 5, defendant shall obtain, maintain, and pay for and have no violations with the ignition interlock device, mobile breath device. Any violation will be grounds for revocation. Do you understand that? Okay. So if you don't have a car, you have to get a mobile breath device. Okay? And defendant must attend NA meetings 3 times a week and provide
Thank you.
proof to the court. Now, you don't have a car, any car that you own or operate must have an interlock device on it. So you can't drive somebody's car.
No, my car when I got the.
Okay, but what I'm stating, even if you drive somebody else's car, it has to have an interlock device on it. You cannot drive a vehicle that does not have an interlock device on it. And you will be required to have your a mobile breath device. Now, do you understand these conditions? Now, if you violate any one of these conditions, your bond can be revoked, and if your bond is revoked, a warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Also, I have a AANA verification form and some locations of the AANA meetings that you can attend in our area or in the area near you, whichever is convenient. Now, please step to the side right here. That's the verification form. A sponsor will sign that every time that you go to a meeting, and you need to bring that form back in the court every time that you come to court. And these are locations in the area that you can attend those meetings at. And again, yeah, it's gonna be in these bond conditions. It's 3 times a week and provide proof to the court. And you're gonna get a copy of this, okay? You need to make a copy of that. Please have a seat in that first chair on the wall. Okay. Tremaine Richardson. Okay, Mr. Richardson, your full name is Tremaine Richardson. Mr. Richardson, would you please raise your right hand? You swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
You may put your hand down. How are you doing, Mr. Richardson?
Doing all right. How you doing?
I'm doing fine, thanks for asking. Mr. Richardson, I have before me 2 documents. The first document is titled Judge's Explanation of Rights of Defendants Without Attorney. You recognize this document? Is this your signature on the line that's titled Defendant? Or are these your initials on the line that state you like to apply for court-appointed attorney?
Yes, sir.
I also have another document that is titled Jefferson County Affidavit of Injuries. You recognize this document? And on page 2, there's a signature above the line that is titled Defendant. Is this your signature? Mr. Richardson, before you signed and initialed these documents, did you read the documents? Did you understand what you read? Is everything in these documents true and correct to the best of your knowledge?
Yes.
Okay, Mr. Richardson, I read your answers. Based on the answers, you meet the eligibility requirements for the appointment of a court-appointed attorney, and the attorney that will be appointed to represent you, in this case, is Attorney John Mason. Attorney Mason will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information, but before she gives you that information, I need to give you some bond conditions And I have a document that is titled Standard Bond Conditions in County Court at Law Number 2. And it states following return of criminal information in County Court at Law Number 2 of Jefferson County, Texas. All bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or the United States. Do you understand that condition? Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test of drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition? And condition number 3 does not apply. Condition number 4 does not apply because your case is not a DWI case. However, condition number 5 does apply. And condition number 5 states that the defendant is prohibited from possessing a firearm or ammunition unless the defendant is a peace officer as defined by section 1.07, the Penal Code, actively engaged in employment as a sworn, full-time, paid employee of a state agency or political subdivision. You understand that condition? Okay, now, Mr. Let's see. Okay, now, Mr. Richardson, if you violate any one of these conditions, your bond can be revoked. And if your bond is revoked, a warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Do you understand that? Okay. Now, Mr. Richardson, you'll get a copy of these bond conditions. Please have a seat in the third chair on the wall and wait for your name to be called. Kay Bass. Okay, Ms. Bass, your full name is Kay Maureen Bass. Ms. Bass, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth so help you God?
Yes, sir.
Ms. Bass, you may put your hand down. How are you doing, Ms. Bass? That's good. Ms. Bass, I have before me 2 documents. The first document is titled Jefferson County, it's titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
Is this your signature on the line titled Defendant? And are these your initials on the line that states you'd like to apply for court-appointed attorney?
Yes, sir.
I also have a document that is titled Jefferson County Affidavit of Indigence. You recognize this document?
Yes, sir.
On page 2 of the same document, there's a signature above the line that is titled Defendant Signature. Is this your signature?
Yes, sir.
Ms. Bass, before you signed and initialed these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
Is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Okay, Ms. Bass, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney, and the attorney that will be appointed to represent you in this case, you have to make a copy of those bond conditions for him. Also, did you give the other young lady a bond condition? Okay. Okay, and so your attorney is going to contact you. You'll be given permission to contact your attorney. Our court coordinator will give you that information. Once you get the information, you're free to go. You have a blessed day. Please have a seat in that second chair on the wall. You're welcome. Todd LeBlanc, thank you. It was Todd LeBlanc.
That's it.
First, you have a case?
Cases, guys in custody. Approach.
Oh, yeah, he's talking about Ansley Rambin?
Yes, Judge.
Yes.
We reset his cases 2 weeks in felony court. He's gonna remain in custody during that time, so.
Okay, so we just have to, did they give you a court date? We have to set it on the same day,
I assume it's 2 weeks, means
From
two
the day?
Tuesdays from now, but
be the 15th.
it's also distinctly possible that I'll be in trial and that'll change, but right now, that's the plan.
Okay, now if it's not in the computer, what we'll do, we'll check and then we'll, set it on the same day.
Okay.
All right,
Thank you.
so you're free now. She's outside waiting for you.
Thank you.
Yeah.
Nikhil Latrell Jackson. Jefferson County Court, Law number 2 is back in session. Court is in session. The case is styled the state of Texas versus Nikhil Latrell Jackson. Ms. Jackson, is that your full name?
Yes, sir.
Ms. Jackson, would you please raise your right hand? Ms. Jackson, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Ms. Jackson, you may put your hand out. How are you doing, Ms. Jackson?
I'm good. How about you?
I'm doing fine, thanks for asking. Ms. Jackson, you're represented in your cases by your attorney, Attorney Jack Lawrence. Attorney Lawrence, how are you doing?
Just fine, Your Honor.
And Mr. Lawrence, do you waive a record in Ms. Jackson's cases?
Yes, Your Honor.
And the state is represented in this case by Attorney Haley Simmons. Attorney Simmons, how are you doing?
I'm great, Judge. How are you?
I'm doing fine, thanks for asking. Ms. Jackson, I have before me in cause number 23CCCR 0477, a document that is titled Information Sheet. This information sheet was filed by the Jefferson County District Attorney's Office. It's you got it. It's supposed to be, it's a class A misdemeanor.
Yes, sir.
Ms. Jackson, do you recognize this document?
Yes, sir.
Now, Ms. Jackson, this offense that you've been charged with is a Class A misdemeanor that allegedly occurred on or about September 20th of 2021, and it stated that you committed a Class A misdemeanor offense of resisting arrest, search, or transportation. Do you understand what you've been charged with?
Yes, sir.
And to this charge that occurred on September 20, 2022, while you were in Jefferson County, Texas, how do you plead guilty?
Yes, sir.
Not guilty, pleading guilty? Now you pleading guilty,
No charges.
you pleading no contest?
No charges.
Okay, are you pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charge?
Yes.
Ms. Jackson, I also have before me a document on this tablet that is titled Misdemeanor Plea Admonishments. You recognize this document?
Yes. Sir.
Now, there's one box that's checked on this document is checked as a Class A misdemeanor, and the range of punishment for a Class A misdemeanor is minimum 0 days to maximum 365 days in the county jail, or a fine that does not exceed $4,000, or you could be given both such fine and confinement. Do you understand that?
Yes, sir.
I also have on page 2, there are a set of initials on a line that's next to a box that's checked nolo contendere, which means no contest. Did you place your initials on this document?
Yes, sir.
Okay. On page 3 of this same document, there's a signature above the line that is titled defendant. Is this your signature?
Yes, sir.
And on the next document that's titled trial court certification of defendant's right of appeal, you recognize this document?
Yes, sir.
Is this your signature on the line that's titled defendant?
Yes.
At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes.
The second box that's checked states that you are waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes, sir.
I also have a document on paper that is titled Discovery Certification. You recognize this document? And is this your signature on the line that's titled
Yes.
defendant? Now, Ms. Jackson, before you signed and initialed these documents, did your attorney go over these documents with you?
Yes, sir.
See that? Ms. Jackson, I noticed that On the discovery certification, you have in Jackson, you said that's your signature, right?
Yes, sir.
And on here, you said your signature says NJ.
I didn't finish Jackson. Yes, yes,
Okay,
sir.
I'm gonna get this document back to you, so you can go ahead on and finish it. Now, I may have to go to the next page. Let me see. Let's see what the previous page. She needed to do the same thing up here.
Oh, it's the same thing again?
Yeah,
Good,
yeah, she just put her initials.
okay, I see. I'm sorry, I didn't notice that, no.
That's all right.
Jackson. Good, good. Good, 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 good.
Thank you.
Yes, Your Honor.
Now, Ms. Jackson, before you sign and initial all of these documents that I just showed you, did your attorney go over these documents with you?
Yes.
And did you understand everything that your attorney went over?
Yes.
Is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Ms. Jackson, are you a citizen of the United States?
Yes, sir.
State over state one.
Any objections to state's exhibit number 1?
No objection, Your Honor.
No objections, state's exhibit number 1 will be admitted. Mr. Lawrence, you advising counsel, Ms. Jackson, is there any evidence that she is currently mentally incompetent to stand trial?
Not that I could see, Your Honor.
Okay. And Ms. Jackson, your attorney, Mr. Lawrence, has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation?
Yes, sir.
Ms. Jackson, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is the agreement?
In exchange for defendant's plea, the state's offering 80 days in the Jefferson County Jail, credit for time served, and to tax and retire all court costs.
Okay, Ms. Jackson, the state is offering that you serve 80 days in the Jefferson County Jail, but you would not have to serve any more time in the Jefferson County Jail because you've already served 80 days in the Jefferson County Jail. Therefore, you'll be given credit for the time that you've already served. The court costs in this case will be taxed and retired. That simply means that you will not be required to pay the court costs because the time that you have spent in jail has already paid off the court costs. Therefore, the court costs will be taxed and retired. Ms. Jackson, do you understand the state's offer?
Yes, sir. I do.
Do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Ms. Jackson, I'll follow the plea bargain agreement that you have entered into with the state. Now we have these, what are we doing with these other two
The
cases?
other two, Your Honor, are basis for a separate felony MTRP. This one was not listed as an allegation.
Okay. Okay, so Ms. Jackson, these, do we have a court date on the MTRPs? Do we know?
I believe they were set for today originally, Your Honor, and give me a second.
Yes, we were. I was over there, yes, and that got reset. I don't know what date that got. reset.
Oh, okay.
I can see if it's in the computer. They have been reset to May 14th, Your Honor, for sentencing hearing.
May 14th
Yes, Your Honor.
for sentencing?
That's what it says. It says MTRP sentencing hearing.
Oh, she must have played.
I don't have any of that in the computer as of yet, though, Your Honor.
She must, yeah, I'm just saying, she must have played and then they reset it, they must have got it, they reset it for sentencing.
I'm not her counsel.
I know that, but I'm just saying, for it to be reset for sentencing, obviously. The guilt and innocent phase is already finished, so then they're gonna go into the punishment phase. Okay, we're gonna reset it. You gonna check and see if it's on, she gonna check right now to see if they gave you a court date. She's gonna check the computer.
Thank
Yeah.
It's set for 1:30 in the afternoon, Your Honor. Just to let you know, it says May 14th at 1:30 PM.
May 14th. Okay,
For NTR.
motion to revoke probation, that's what it's called. MTRP, we just abbreviated.
Is that in Stevens? Judge Stevens?
No, that's with Judge West.
Judge West.
PSI.
Yeah, they doing sentencing on May 14th. Okay,
Thank you.
okay, Ms. Jackson, she's already been, okay, you can follow the bailiff and you have a blessed day.
Y'all too.
Thank you. Do we know anything, the situation on Mr. Richards? Court is back in session. Next case is cause number 25 CCCR 0332. Case is styled the state of Texas versus Jalacia Miles. Jalacia Miles is scheduled to be in court this morning at 9 a.m. for the court's arraignment docket at about 9 a.m. Court's bailiff called the name of Jalacia Miles at the courthouse door. Jalacia Miles did not answer. Jalacia Miles has not appeared in court since the court's been in session. The time now is 11:34 a.m. on today's date, April 1st of 2025. Ms. Bailiff, would you please call the name of Jalacia Miles at the courthouse door?
Delacia Miles. Delacia Miles. No response, Your Honor.
Jalacia Miles' name was just called again at the courthouse door. Jalacia Miles did not answer. Reasonable time has passed to give Ms. Miles the opportunity to appear in court. She has not appeared in court. State, do you have a motion? That motion will be granted. Jalacia Miles' bond will be forfeited and warrant shall be issued for arrest. And cause number 25 CCCR 0332. Next case is cause number 25 CCCR 0341. Nope, that's not it. That's the next case. Cause number is 25 CCCR 0260. Case is styled state of Texas versus Caitlin Van Duren. Caitlin Van Duren was scheduled to be in court this morning at 9 a.m. At about 9 a.m., of course, we have called the name of Caitlin Van Duren at the courthouse door. Caitlin Van Duren did not answer. The time now is 11:35 a.m. on today's date of April 1st of 2025. Ms. Bailiff, would you please call the name of Caitlin Van Duren at the courthouse door?
Caitlin Van Buren. Caitlin Van Buren. No response, Your Honor.
Caitlin Van Duren name was just called again at the courthouse door. Caitlin Van Duren did not answer. A reasonable time has passed to give Ms. Van Duren the opportunity to appear in court. She has not appeared in court. State, do you have a motion?
State request the bond court to pay, Your Honor.
That request will be granted. Caitlin Van Duren's bond will be forfeited and warrant shall be issued for her arrest. And cause number 25 CCCR 0260. Court will be in recess. Put us back in session with the arraignment docket. Court is in session. Court is in session. Jose Rivera. Court is in session.
You said that's not his name.
Jose Alberto Rivera.
Rodriguez?
Yeah.
Okay, his name is Rodriguez.
I thought we were supposed to go to bond for Jose.
Oh, that's the other one. Okay.
Yeah.
That's fine.
Okay, this is, three, oh, oh, four. Oh, three. Oh, four. Okay, court is in session at cause number 25 CCCR 0304. Case is styled the state of Texas versus Rudy A. Rodriguez. We have Mr. Rodriguez, who's present in court. Mr. Rodriguez speaks Spanish. We have Ms. Jennifer Araji, who is our interpreter. Mr. Araji, would you please raise your right hand? Do you swear to interpret Spanish to English and English to Spanish to help you God?
Yes, Judge.
You may put your hand down. How are you doing, Ms. Araji?
Good judge, thank you.
That's good. I'm doing fine, thanks for asking. And Ms. Araji, ask Mr. Rodriguez if his full name is Rudy A. Rodriguez.
Yeah.
Okay, you ask Mr. Rodriguez to raise his right hand. Mr. Rodriguez, do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Okay, yeah, he can put his hand down. How are you doing, Mr. Rodriguez?
Yeah.
Good.
Good. Mr. Rodriguez, I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants. You could show him these documents. I'll just mention each one of them. You have before you a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize that document?
See.
Yes.
Okay. Mr. Rodriguez, is that your signature on a line that's titled defendant? And are those the initials on the line that is titled you'd like to apply for, that states you'd like to apply for a court appointed attorney? Now, do you recognize the other document that is titled Jefferson County Affidavit of Indigence?
Yes.
Now, on page 2 of that document, there's a signature above the line at the top left-hand corner that's titled Defendant's Signature. Is that your signature?
Yes, it's Yes, Judge.
Okay. Now, Mr. Rodriguez, before you sign and initial those documents, did Ms. Araji go over those documents with you in Spanish?
See.
Yes. And did you understand everything that she went over?
Yes, Judge.
And is everything in these documents true and correct to the best of your knowledge?
Yes, Judge.
Okay. Now, Mr. Rodriguez, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Charles Rojas. Mr. Rojas will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you're free to go, and you have a blessed day.
Dice que la van a ver a su cargo. Y a usted la atención de su apoyo. Y la van a dar la segunda información de todo. Y luego, cuando se termine con ello, lo que puede decir es que tengo un.
Okay, please.
Frente de.
All right,
Or
thanks a
she-
lot, Miss, yeah, we could give it to her. Oh, now you need to get him to fill out that portion, Don sworn declaration part. Okay, this will conclude, well, yes, court is back in session. Cause number 25 CCCR 0341, case of South State of Texas versus Jose Alberto Rivera. Jose Rivera is scheduled to be in court this morning at 9 a.m. At about 9 a.m., the court's barely calling the name of Jose Rivera at the courthouse door. Jose Rivera did not answer. Jose Rivera has not appeared in court since the court has been in session. The time now is 12:04 p.m. on today's date. Ms. Bailiff, would you please call the name of Jose Rivera at the courthouse door?
Jose Rivera. Jose Rivera. No response, Ron?
Okay, Jose Rivera's name was just called again at the courthouse door. Jose Rivera did not answer. A reasonable time has passed to give Mr. Rivera an opportunity to appear in court. He has not appeared in court. State, do you have a motion? That motion will be granted. Jose Rivera's bond will be forfeited and a warrant shall be issued for his arrest in cause number 25 CCCR 0341, and this will conclude the calling of the court's arraignment docket or initial appearance docket on April 1st of 2025 in County Court at Law number 2 of Jefferson County, Texas. Judge Terrence Holmes presiding. Everyone, please have a blessed day. Prosecutors, you're excused.
Thank you, Judge.